Well, friends, in his federal case down in Florida, Donald Trump just threw a Hail Mary pass, asking the judge to just dismiss the case against him, just throw out all the charges. Let's hope that Donald Trump's favorite judge down in Florida, Judge Aileen Cannon, isn't standing in the opponent's end zone waiting to catch Donald Trump's Hail Mary pass. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, just like he did in his federal case in D.C., Donald Trump has now filed a bunch of bogus motions to dismiss his federal prosecution in Florida, urging the judge to just throw out the entire case, dismiss all of the charges against him. I've done a quick review of Donald Trump's motion to dismiss. He asserts 6 or 7 different reasons why the judge should just throw out the entire case. And let me tell you, the motion to dismiss is like a house of cards built on a foundation of sand. It's not going to take much for Special Counsel Jack Smith to knock it all down. Let's start with a new reporting. This from the Washington Post. Headline, Trump again claims immunity in effort to toss Florida classified documents case. Donald Trump's lawyers argued that the former president declared the classified materials were his personal property before leaving the White House. Oh, wait a minute. I guess we didn't know that before he left the presidency, Donald Trump declared that all the classified documents, all of the national defense information, some of our nation's most closely guarded secrets, all belonged to him. And that's why he was allowed to just take it all with him when he left the White House, when he left the presidency. Case dismissed. Friends, that would be like Donald Trump arguing, before I left the presidency, I declared that all the money in the U.S. Treasury belonged to me. So I was just allowed to take it all when I left the White House. Come on, man. That Washington Post article begins, Donald Trump's attorneys said late Thursday that the former president should never have been charged in Florida with illegally retaining classified materials because he designated them as personal documents before leaving office, and thus should be shielded from prosecution by presidential immunity. It's the second time Trump has tried to avoid a federal criminal trial with the sweeping argument that he cannot be prosecuted for any actions that occurred while he was president. A judge and an appeals court panel have rejected that claim in his Washington, D.C. trial for allegedly obstructing the 2020 election results, but Trump has asked the Supreme Court to intervene. The Supreme Court's decision could settle the question of presidential immunity in both the D.C. and Florida cases. The immunity court filing Thursday night was one of at least a half dozen requests by Trump's attorneys in Florida to toss out the 40-count indictment, which accuses Trump of mishandling classified papers after he left office and obstructing government efforts to retrieve them. Trump has pleaded not guilty. Other motions cited allege prosecutorial misconduct and selective prosecution and vindictive prosecution. Trump has unsuccessfully made some of the same dismissal arguments in the federal D.C. case. Okay, friends, let's just stop there and let's quickly tick through the ridiculous assertions that Trump and his lawyers put in this motion to dismiss. presidential immunity, right? Absolute immunity for all crimes that he commits in violation of our nation's laws and against the American people while he is President of the United States. There is no such thing as absolute presidential immunity against prosecution. The trial court judge in D.C. already ruled and denied the motion. A unanimous appellate court panel in D.C. ruled and denied the motion, saying there is no such thing. The Constitution provides that a president can be prosecuted for crimes he commits while in office, even if he's impeached for those same crimes. So there's no such thing as absolute presidential immunity. And of course, we're waiting for the Supreme Court to either say that, or really the better course is for them to say, we're not even going to review the D.C. Court of Appeals denial of Trump's motion because there's no there. So Judge Chutkan, here you go. We're giving you the case back. Put it on the trial track in Trump's D.C. prosecution. Okay, absolute immunity is laughable. No such thing. Something else Trump claims, the Presidential Records Act lets a president do it. Just grab those classified documents and take them with you. Here's the problem. The Presidential Records Act, which came into existence in the aftermath of Watergate, actually says that the records belong to the government, not to the president, right? So the Presidential Records Act actually provides the exact opposite of what Donald Trump is claiming. So that motion will be denied. He also says that the statutes that he's being prosecuted under are void for vagueness. I know that sounds like a funky phrase, but there is actually a legal doctrine called void for vagueness. If the criminal statute that you're being prosecuted under is so void that you just can't make heads or tails of it, it violates the Constitution because I'm not even on notice of what I have to defend against. There is a thing called void for vagueness. It is a challenge that can be made against a federal statute that you're being prosecuted under, but it's almost never successful. Why? Because before federal laws are enacted, they go through extreme vetting in the House, in the Senate, by the President of the United States before he signs it into law. So void for vagueness challenges are almost never granted, and Donald Trump's assertion that the statutes are void for vagueness will be denied. Another claim he makes is something called selective prosecution. You know, Joe Biden isn't being prosecuted, wasn't prosecuted for having classified documents in his garage, so I shouldn't be prosecuted. Yeah, that's the ticket. It's selective prosecution. On the surface, it does sound like it could be selective, but here's the problem. The legal doctrine of selective prosecution is very hard to make out. In fact, the leading case, I don't want to turn this into a Team Justice Law School class, but I teach selective prosecution to my students at George Washington University. The leading Supreme Court case is called the Waite case, and it arose out of the military draft, the Selective Service. Let me do a quick breakdown of this. There were more than 670,000 people who failed to register for the draft, non-registrants, and it was a criminal offense. And of the 670,000+ people who failed to register for the draft, do you know how many were prosecuted? 13 people. Sounds pretty selective to me, and those 13 defendants made a claim, tried to, file a motion to dismiss the case based on selective prosecution. Here's what the Supreme Court said decades ago. First of all, they said something that was a little cute for the Supreme Court. They said, a successful selective prosecution claim is a rara avis. What is that? It's Latin for rare bird. Good one, Supreme Court. A successful selective prosecution case is a rare bird indeed. Why? Because the defendants would bear the burden of proving that the prosecutors brought charges selectively that were designed to discriminate against somebody, both in their purpose and in their effect. And even that case, the claim of selective prosecution, 670,000, but you only prosecuted 13 people, was denied. Donald Trump's claim of selective prosecution will be denied, just as his claim of vindictive prosecution will be denied, just as his claim that Jack Smith is somehow an illegal rogue special counsel, he wasn't legally appointed, will be denied and has been denied previously. So Donald Trump's motion to dismiss will go nowhere because the claims are laughable. Here's my only concern. Who will be deciding this motion to dismiss? The Trump-appointed Judge Aileen Cannon, Donald Trump's favorite judge. I think he even likes Aileen Cannon more than he likes the Supreme Court justices he appointed, who he keeps suggesting should do him a favor, though, because after all, I appointed you. So these motions will be taken up by and resolved by Judge Cannon. If Judge Cannon is an honest broker of the law, she will deny these motions. Is Judge Cannon an honest broker of the law? I think that remains an open question. She's done so many favors for Donald Trump during the course of this litigation and even before this criminal case was brought. And she has been so antagonistic to everything that Jack Smith has said or done that I am still hopeful at some point Special Counsel Jack Smith decides to file a motion to have her removed from the case, to have her recused. Remember, the federal law, the standard for removing a judge from a case is if the judge's impartiality might reasonably be questioned. Reasonable people, indeed experts across the spectrum, have been questioning Judge Cannon's impartiality since the moment the 11th Circuit Court of Appeals, the appellate court sitting over Judge Cannon, ruled that she abused her discretion by doing an enormous favor for Donald Trump early on, after the documents, the evidence of Donald Trump's crimes was seized from Mar-a-Lago. She abused her discretion and interfered with an ongoing DOJ investigation into those documents and into Donald Trump. I would say that for openers, her impartiality might reasonably be questioned. So I still hope, perhaps naively, I still hope that Jack Smith decides that finally there is enough to file a motion to recuse, to remove Judge Cannon from the case. And then, friends, we get to see the issue litigated in the full light of day. First, Judge Cannon will have to make a decision whether she should remove herself, and if she refuses, that can be appealed up to the 11th Circuit Court of Appeals, which has already smacked her down a couple of times. And then we have to live with whatever the 11th Circuit Court of Appeals rules. Either she should be removed from the case, or there's not quite enough evidence to remove her from the case, and she can remain the presiding judge, but only if we litigate it, and only if all of the facts are presented, the law is applied to those facts, and the 11th Circuit issues an authoritative opinion, a decision on the issue of recusal. I think can we all feel comfortable that, okay, this question has run its course, has been litigated, has been resolved, and now let's keep moving forward in Donald Trump's federal prosecution in Florida for unlawfully retaining government documents, for obstructing justice by defying a grand jury subpoena in a criminal investigation to return the documents, and for violating our nation's espionage laws because some of the charges that have been brought against him involve his unlawful retention of national defense information. And those charges fall under our nation's espionage laws. So let's hope that this issue gets resolved, gets raised, gets litigated, gets resolved, because we need to have confidence in the way Judge Cannon addresses this absurd motion to dismiss brought by Donald Trump. We need to have confidence that the case is being adjudicated fairly by Judge Cannon or whoever ends up presiding over the Florida prosecution. We need to have confidence in the outcome, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.